Hi, and welcome back to the Sidebar with Gary Barton. I'm your host, Gary Barton. Today we're going to be talking about common verbiage when we're dealing with child custody matters. Hi, and welcome back to the Sidebar. I'm Gary Barton, and today we're going to be discussing common verbiage used in Texas when we're dealing with child custody matters. It is a little tricky if you have never grown up around child custody matters in Texas or are new to this state. We have something called conservatorship versus custodianship. They sound similar, but they in fact are drastically different. And what does that mean if I want to be a joint parent with my spouse or soon to be ex-spouse? Or do I want to be a sole managing parent without my ex-spouse being involved at all? We're going to be talking about that. So when we're dealing with family law in general, keep in mind that the courts are going to try and encourage both parents to co-parent with each other. That is the whole concept behind family law when you take a 30,000-foot view of what is designed for the court system here in Texas. We want both parents to be involved as much as humanly possible. But what does that look like when it comes to verbiage? Well, let's first start off with conservatorship. There are two different types of conservatorship. There is what we call joint managing conservators or sole managing conservators. And if you have this idea that I need quote unquote full custody, what does that mean for me? You oftentimes are going to jump to, oh, I have to get sole managing conservator. And that's where understanding what conservatorship actually means in Texas will help you better understand what a judge is going to likely rule and what we probably need to be setting for your goals in your specific matter. Joint managing conservator is going to be the default for judges. Again, joint managing conservator is going to be the default for judges in most scenarios. And what that encourages is co-parenting with each other. Joint managing conservatorship or conservatorship in general, all that is talking about are the legal rights to my children. The legal rights to my children, not who physically has possession of the children. That is called custodianship, okay? So when we're dealing with conservatorship, we're dealing with legal rights to the children. What do I mean by legal rights? Legal rights are very, very basic legal rights that you have as a parent unless they get taken away from you. The most common ones, the two biggest ones, there are several of them, but the two biggest ones that you're oftentimes going to discuss when we're dealing with divorce are going to be the right to determine medical procedures for my children and the right to determine educational issues for my children. What does that mean? Well, if little Johnny has to have a surgery, the idea is that both parents, no matter if it's 10 years post-divorce or 10 years post having a SAPSR order, you need to discuss this with your ex and make sure that you guys are on the same page when it comes to deciding what is best for little Johnny. That is the medical side of the legal rights. Education side, very similar. Obviously, we're dealing with school. Should little Johnny go to private school? Should he go to public school? What school district? Is dad's better than mom's? And so those are things that the court system encourages you to discuss and come to a mutual agreement. If you cannot reach a mutual agreement between two people on those basic rights with your children, that's what we need to go forward and potentially have addressed by a judge at a later date when that issue arises with your children. And so those are the two biggest issues that come up when we're talking about the legal rights, the conservatorship of your children. Now, that is drastically different from custodianship. Custodianship is now who physically has possession of little Johnny on what day and at what time. That is going to be custodianship, possessory rights. And so possessory rights are oftentimes going to be designated as one parent versus the other as the primary designation for residence. So you'll oftentimes hear the verbiage, who has primary residence? Is it mom or dad? You may even share a 50-50 custodial arrangement. Maybe little Johnny goes 1 week on with dad, 1 week on with mom. That doesn't mean there's not a primary residence that has been designated by the court or agreed upon. And that primary residence is going to dictate oftentimes where we're considering little Johnny's home to actually be. And that oftentimes is also going to include where they go to school because of that surrounding school district that they are now placed in because of that primary residence. Now, a common question I get asked, do I have to designate a primary residence? The answer is actually no. You don't have to. If you want to agree with your spouse or soon-to-be ex-spouse going through a divorce or a SAPSR that little Johnny does not have a primary residence, you can do that. Now, it may pose complications later on down the road when we're dealing with school matters, but it is very, very possible not to designate a primary residence if this will be worked out or you intend to work this out with mom or dad as the other ex-spouse. And so that's what we're talking about when it comes to custodianship. If we are dealing with a primary custodian, that parent, oftentimes referred to in social media, primary parent, that primary parent is likely going to be the home base for little Johnny. Now in Texas, we do pretty much have a default system put in place unless agreements are reached with both parties or special circumstances arise. This is a very conservative state and typically referred to as a mom-friendly state. Now, that does not mean that dads don't have excellent rights, and with the right attorney, dads can walk away as primary custodian, but as a general rule of thumb, most people view Texas as a mom-friendly state because of this, because the default is oftentimes to designate mom as primary custodian, again, the primary residence or primary parent, and putting dad on some sort of standard or extended standard possession order. That calendar oftentimes is going to look like dad gets little Johnny every first, third, and fifth weekend of the month, if there is a fifth weekend of the month, which happens about twice a year. And so it's kind of that every other weekend scenario that you will commonly hear about. And that is the default that we're dealing with. Now, the difference between standard and extended standard possession order is going to be when dad gets to take possession of little Johnny. Little Johnny is going to either be on a standard at Friday at 6 p.m. or extended Thursday at 6 p.m. and then continue with that every other weekend schedule, every first, third, and fifth weekend of the month. And so that is the default. Now, does that mean that is applicable to you, especially if you're a dad listening to this and thinking to myself, oh my God, I'm screwed? That's not what I'm talking about. There are special circumstances for every case, and we just need to make sure that those are addressed and your rights are kept in place so that way you have a very healthy relationship with your child moving forward. But that is the big difference between conservatorship and custodianship. Conservatorship, again, remember, legal rights to the children, very basic. Custodianship, we're dealing with possessory rights. Who has possession of the children and on what time and on what day. That schedule has been put in place. Who is designated a primary residence, if any, and also oftentimes referred to as primary parent. And so that is really what most courts are going to consider full custody. If you're going after quote unquote full custody, that means you are going to be going after primary custodianship of your children. Now, going back to the difference between conservatorships, again, remember, the default is joint managing conservator. Unless one spouse or one parent has a major issue that they cannot physically care for a child or mentally care for a child, whether or not it's drug abuse, incarceration, just lack of being their presence, then you're going to oftentimes default to joint managing conservator. There are special circumstances that arise where one parent is designated sole managing conservator. Sole managing conservator means I don't have to deal with the other parent when it comes to those legal decisions, educational, medical issues. And so that cuts the other parent out from those discussions. That also means, by default, if you are designated sole managing conservator, that the other person likely only has visitations, if at all. And so visitations are not the same thing as custodianship, okay? That may mean they only have some sort of visitation rights, could be supervised, may not be supervised. But visitation rights are different from custodial rights. Custodial rights give you actual legal authority over your child when you have possession of them. And so if we're dealing with a scenario that we're asking for sole managing conservator, it's likely due because the other parent has done something pretty bad that's not going to be considered by a judge to be a good fit for them to be legal rights to those children or custodial rights to those children. And so, again, every case is specific when it comes to its facts and the exceptions to the rules, but this is a quick glimpse into the difference between custodial rights and conservating rights. And so this is the Sidebar with Gary Barton. I hope this will help you understand conservatorship versus custodianship. Click like below, subscribe to our podcast, find us on social media, and like us and follow us for more content later on down the road. Thanks for tuning in.